Hello, my name is Angela Princewell, and today I want to talk to you about how you may still be considered a spouse for spousal support purposes, even though you and your partner maintain separate residences throughout your relationship. So, from your perspective, you may be considering the other person as simply a boyfriend and or simply a girlfriend, but under the Ontario Family Law Act, they may still have a claim against you for spousal support. I recently did an interview on this issue, and a lot of people have reached out. There's been a lot of buzz and interest. And those who reached out just simply could not believe it. It's like we are maintaining separate homes. How can it possibly be that I'm cohabiting with this person under the law? Well, each case, of course, always turns on its own facts. The facts of the case I was talking about that I was interviewed on, the couple did not live together except on weekends and sometimes during vacations. They both each had their own homes. Their children lived separately in their separate homes, and still the courts found in that case that the parties were cohabiting. So each case turns on its facts. The courts would look at things like, what were the parties' intentions? Was this a committed relationship? Did they, put themselves out to family and friends as a couple in a committed relationship? As you may know, under Section 29 of the Ontario Family Law Act, a spousal or spouse for spousal support purposes includes two persons who are not married but who have cohabited continuously for a period of 3 years or more. And it also includes obviously people who are in a relationship of some permanence if they have a child together. But in this instance, we're dealing with people who do not have a child together but who have cohabited for 3 years or longer. Now, it all turns on what is cohabitation. The courts have found that continuous cohabitation does not mean that you have lived together with this person, all the time at a fixed address. Your living arrangement is just one factor the court looks at in determining if you have been cohabiting. So other factors the courts would look at include what's the level of commitment in the relationship, what was the length of the relationship, what was the financial arrangement that the couple had during the relationship. Now, financial arrangement doesn't just stop at, we had separate accounts, we didn't own anything jointly. No, that's just a factor, but the courts look at what financial dependency existed during the relationship. Lavish gifts, for example, making rent payments for the person. Did that person quit work so that they can be around you to be able to, attend social events and things like that with you? The courts would look at the extended family and friends. How were you perceived to them, by them? In some cases, there's people who have been long-term relationships that even friends and some family don't realize that they're not married, and perceive them as a married couple. Did you ever refer to that to your partner as, my wife in some situations? So those are all the factors, interestingly, that come into determining cohabitation, not just whether or not you live together at the same fixed address. From the court's perspective, from perspective in the family law context, when you're looking at a party continuously cohabiting for a period of 3 years or more, the courts recognize that your living arrangement, while just one factor, is also living arrangements vary. So they're not going to just look at how you lived and where you lived, which is unfortunately a factor that a lot of people focus on when they're thinking about cohabiting. And unfortunately, that's not the case when you're interpreting continuous cohabitation under the Ontario Family Law Act. So someone asked, are you telling me my boyfriend can get spousal support from me even though we are just dating? Well, as always, the answer is it depends. If the only basis on which you're relying on saying you're not continuously cohabiting is the fact that you maintain separate addresses, well, that may not be enough. So think about all the other factors that I've said, how, you're perceived in the community, the financial dependency, length of relationship, and things like that. The courts would look at all of that as a whole and decide whether or not there exists a spousal support obligation in that case. As always, you should get independent legal advice on whatever the nature, depending on the nature of your relationship. If I'm a believer in making informed decisions. If you speak to a lawyer, it doesn't matter what their advice is in any particular situation. It just means that you're going into it informed, and the worst thing is having a relationship end and finding out that you have all of these obligations which you did not intend to carry on. We're always here at AP Lawyers. We're open late so we could take your questions, and reach out if you want to understand what your obligations are in your relationship in the event that it does break up.